George, Duke of Clarence, Catherine Howard, Margaret Beaufort, Edward IV, Richard III, Thomas Cromwell, Henry Tudor, and many other well-known figures are not only united by the fact that they were of great importance to English history. At some point, their names became the subject of a so-called Bill of Attainder. I have used this term repeatedly on this channel, but I have never explained it in detail. This is, in fact, necessary because a merely superficial examination does not reveal how tyrannically these laws could be employed. Welcome back to Lemmy History. At the moment, I am dealing a great deal with legal topics on this channel. This is also because I have to do so for my actual work at the university. I am a strong advocate of first clarifying the legal foundations, especially in cases of violent conflict. In this way, it becomes possible to demonstrate why reality diverged from them. This, in turn, makes it easier to analyze the underlying causes. We can then ask why, or at what point, the body of law proved insufficient to permit the orderly resolution of conflicts. To do this, however, we must first understand precisely the significance of the legal instruments themselves. So let us begin with a definition. I am strongly guided here by the remarks of Cornell University, but I omit the specifics concerning the United States for obvious reasons. Bills of Attainder are special laws of Parliament that impose death penalties and other sanctions on persons who have allegedly committed serious crimes, such as high treason or aggravated theft, without a conviction in the ordinary course of judicial proceedings. If a law imposes a milder punishment than death, it is called a penal and penitential law. In England, however, during the late Middle Ages and the 16th century, they were often referred to as Bills of Attainder. In the case of a Bill of Attainder, the English Parliament therefore exercised a judicial function, even though it constituted the legislative power. The actual judiciary was bypassed. Ideally, both chambers of Parliament in England voted for the attainder. With the consent of the monarch, the decision became law and could then be executed by the Crown. A Bill of Attainder deprived a specific person of a right as punishment, in the most extreme cases, of the right to life. Attainders could also be issued posthumously during the period relevant to us. This made it possible to confiscate the property of the condemned retroactively. Such sentences could also be passed in absentia. This was the case, for example, with Edward IV and the future Richard III, when they were attainted in 1470. Because these are acts of law, judicial review was not possible. The courts were obliged to decide cases based on the laws as enacted. The Bill of Attainder itself would form the legal basis for such proceedings, as it already determined both the verdict and the punishment. Only, Bills of Attainder arose from English common law. This is true even though they actually contradict the provisions established by the Assize of Clarendon of 1166, the Magna Carta, and several other fundamental legal pillars of the English Constitution. In principle, the circumvention of the judiciary should have been impossible. These cases usually concern the person of the monarch and/or his family. High treason is the most common example, as it punished direct actions taken against the authority of the crown. Inevitably, this meant that the person of the king, his wife, or for example, the heir to the throne, could become the target. That it did not necessarily have to be the king himself is shown by the first case we can reliably identify in English history. In 1326, Hugh le Despencer, the younger, and his father were sentenced to death by means of a Bill of Attainder. We know this because the attainder was reversed in 1398 at the request of one of their descendants. The driving force behind their condemnation in 1326 was not King Edward II, but rather his wife, Queen Isabella, who effectively ruled the kingdom alongside her lover Roger Mortimer. Subsequently, the attainder was backdated to the first year of the reign of Edward III, so that the monarch's formal approval could be demonstrated. During the Wars of the Roses, Bills of Attainder developed into a political weapon, eagerly employed by the Tudor and later Stuart monarchs as well. By the 18th century, the use of such laws had gradually declined. The last known case, issued by a British monarch, dates from 1798 and originated in Ireland. These laws were finally abolished in 1870. The prohibition on Bills of Attainder was ultimately imposed to prevent intergenerational punishment. No one should have to suffer for what an ancestor had done. This principle highlights why Bills of Attainder were perceived as at least arbitrary and not infrequently as tyrannical. This perception became even clearer during the 18th century, when such laws were used less and less frequently. To this day, justice in Great Britain is formally pronounced in the name of the king. In our own time, this is merely a formulaic expression, as the monarch no longer presides over courts or personally chooses judges. Nonetheless, prosecutions are still brought in the name of the crown. The case of George, Duke of Clarence, illustrates vividly why this was such a profound problem when the person of the monarch was directly involved. King Edward IV himself led the prosecution against his brother on behalf of the crown. In a regular court case, the verdict would have been issued in his name, that is, under his authority as king. From a legal standpoint, however, this is untenable. The plaintiff cannot simultaneously be the judge in a fair trial. This is why a subtle but crucial distinction exists between an indictment brought by the crown and a verdict pronounced by the monarch. The charges are initiated by public authority. The monarch's authority merely gives the verdict its legitimacy. When the monarch himself is the party affected, another institution must therefore provide this legitimacy. In England, only Parliament could serve this function. Yet Parliament found itself in a precarious position whenever the monarch demanded an attainder. Returning to our example, Edward IV accused his brother of treason. Had Parliament acquitted the accused, it would effectively have declared that the king had wrongly accused his own brother of treason, or that it refused to punish so grave an offence. Rejecting an attainder thus risked a direct conflict with the monarch. Later, this balance of power was reversed. Under King Charles I, Parliament itself passed an attainder against an unpopular member of the government, forcing the king to sign the measure. He could not simply dismiss a parliamentary conviction for treason as unfounded. It is well known that Charles I was frequently at odds with Parliament, and this reversal of pressure from the Crown upon Parliament to Parliament upon the Crown was one of the reasons why all parties came to see Bills of Attainder as increasingly undesirable over time. Before that shift, however, the situation had been clear. Parliament had to agree to a conviction or face confrontation with the king, a risk few were willing to take. George of Clarence had, after all, betrayed his brother more than once. Thomas Cromwell fell victim to political opponents. Catherine Howard lacked sufficient domestic power to save her life. The Despensers were widely hated, as was Roger Mortimer when he fell in 1330. Bills of Attainder thus served as convenient instruments of royal power, enabling monarchs to eliminate opponents while maintaining plausible deniability. They themselves did not pronounce the verdict. It was not their direct authority that condemned the accused. In the case of Catherine Howard, Henry VIII even delegated his consent to a commission so that he could appear as officially uninvolved as possible. Parliament, for its part, could adapt the legislative procedure for an attainder to each individual case. The accused might be granted the right to defend themselves, but this was not mandatory. Nor was there any prescribed time frame for the process. At first glance, a Bill of Attainder might appear to be an appealing solution. The king formally relinquishes judicial authority in cases that concern himself. Yet the consequences for the accused are catastrophic. They lose the rights they would normally possess within the regular court system. In most cases, they are unable to defend themselves, and Parliament would have to openly defy the monarch to prevent a conviction. Since the king himself controlled the prosecution, he could easily refer cases to Parliament at his discretion. This reveals the tyrannical character of the Bills of Attainder. Regardless of what had truly happened, the king could send his enemies to their deaths and let Parliament do the dirty work. Thank you for watching. Please like and subscribe.